Let's make a start. Hello, everyone. Welcome to Spruson and Ferguson's first webinar in a three-part series titled IP Strategy Roadmap for the Food and Beverage Industry. We bring this to you in partnership with the Riddet Institute, Centre of Research Excellence, and with funding through the High Value Nutrition National Science Challenge. My name is Mike Zammit, and I am a Principal and the Chemical Life Sciences Practice Group Leader at Spruson and Ferguson, Australia. Our presenter today is Dr. Peter Brown, who is also a fellow principal in our team, specialising in the food and beverage sector. Peter has considerable experience working with his food and beverage clients to help develop IP strategies and progress commercially important patents both locally and in New Zealand and in Australia, as well as the target overseas markets. Prior to joining us, Peter worked in-house as an innovation manager and a patent attorney for a large multinational food company, and also has been a co-founder of a startup food technology company. Today, Peter's first webinar will start off by setting the scene of why IP rights are important for the food and beverage industry, laying the groundwork of different IP rights used in the sector, including health claims, highlighting some key pros and cons, and a mock case study to bring it all together at the end. And I hear there's a spot quiz to check that people are listening. As a firm, Spruson and Ferguson's patent attorneys have extensive experience filing and prosecuting food and beverage related patents, for example, in the fields of dairy, milk and milk solids, yeast, wheat and grains, fats, oils and lipids, natural and artificial sweeteners, proteins and amino acids, as well as manufacturing, storage and packaging technologies. In terms of logistics, today we are using Zoom's webinar settings, meaning everyone in the audience is on mute with the video turned off, and I understand nobody can turn either of those on. There's a live chat function at the bottom of your screen, and you can use that to submit questions to us during the webinar, and I'll raise as many of those as I can at the conclusion of today's webinar. We will also follow up with individuals with answers to any questions that do not get answered today. Today's webinar is being recorded, and we'll send all registrants a link to the recording over the coming days and a copy of the slides. So with all that in mind, I'll now hand over to Peter to get the presentation underway. Thank you, Peter.
Thank you, Mike. Hopefully you can hear me okay. So yes, as you'll see in the title that you're looking at now on the screen, this was the roadmap report, and these webinar series was actually developed for the New Zealand food and beverage sector on the basis that it was actually funded through the High Value Nutrition, which is a government funded group in New Zealand. But I think the important point here is for those that are joining from overseas, and in particular, having looked at the attendee list, I've seen there's people from Australia, people from Denmark and Singapore as well. So welcome to everybody joining. And I think that a lot of the insights here will be applicable regardless of whether you're in New Zealand or not. But I see there's a lot of people in New Zealand, so welcome and kia ora to everyone. In particular, I just want to reach out to everybody in New Zealand and North Island especially that have really been struggling with the awful weather that you've been getting there, and just hope you're staying warm and dry as best as possible. Okay, so I will get started. So as Mike said, this is a three-part webinar series, and today we're going to be really focusing on the building blocks, setting the scene in terms of the different types of IP that's used in the food and beverage sector, and then we'll build on that in the next two webinars. One of the questions you probably have is, what about these the webinar links for the future ones? We will be sending those out shortly, and so you can register for those as well. Just to kind of cover off what's going to be covered in the second and the third webinars. The second one's really going to be focusing on really looking as a deep dive on the patenting journey and actually making money from those patents, all the way from when you start from your idea as a concept all the way through to in market. Everything to do with milestones, timing, costs, and all those types of things. And then the third one, which everyone really always enjoys, is and important obviously, is how to avoid those IP disasters and those really bad conversations that you have to have sometimes to fix problems. Obviously, things like managing costs in relation to IP rights, confidentiality issues, IP ownership, and of course, the dreaded patent infringement or other type of IP infringement. So just as a bit of a housekeeping as well, since I've got everybody here online, we've also got a webinar series that's again through the High Value Nutrition group, and Spruson and Ferguson is involved with that. It's slightly different to this IP strategy roadmap, and it's more around patent landscape insights on a whole bunch of different topics. These have been going on for probably about 5 or 6 years now. And now we're into tranche 2 of the High Value Nutrition funding. We're I think about 2 years into the 4-year program. So just as an idea of a few that are coming up, we've just finished a report on the micronutrient fortification, and there's also a report on New Zealand food and beverage insights, so looking at what New Zealand's specifically doing versus the rest of the world. That's on the 28th of this month. In April, we're looking at the global food for health patent trends. I've just finished that report a couple of days ago, and there's some really interesting stuff happening there. And then finally in June, there's one looking around new technology, medtech type devices that are being used, particularly in the likes of clinical trials that are being used in the food and beverage sector these days. And I'll just highlight, this is also in conjunction with Smart Regulatory Solutions group that will be in this Patent Insights and Regulatory webinars. Michelle will be talking about the associated regulatory type issues that arise in these types of areas as well. So when we send through an email following this, we'll try and include the link to these webinars as well that you can sign up for. So just in terms of what's going to be covered today, just in a bit more detail, obviously, what is intellectual property and why is it so important in the food and beverage sector? How to kind of kickstart your IP strategy. So everything in red here is what I'm going to be covering, and everything in blue or whatever color that is, black, will be covered in subsequent webinars. Be looking at some relevant types of IP beyond just the conventional ones and the pros and cons of each. I won't go into the kind of timeline of the patent. I'll leave that till next webinar, but I will kind of touch on the trademark and design application process. And then, like Mike said, I'll have one case study today to look at how IP rights can be used in the and different types of intellectual property can be used in companies in this space. So just to kind of set the scene, so looking at the global food and beverage industry, it's obviously very, very large, $7 trillion US and increasing at a rate of 7% CAGR. And I think that when you look at New Zealand specifically, and perhaps some of these other countries that are OECD countries that are of similar size, focused in the food and beverage sector, it does account for a very large percentage of our export market. In New Zealand, it's about 46% roughly. That was in 2020. And in one of the recent MB reports, again, 2020, they estimated it was about $71 billion. And I'm just picking out a couple keywords. It was ripe for growth. And in particular, they saw that there's going to be huge potential for these value-added products. And it's the likes of these value-added products that the reason why High Value Nutrition was set up, so that we can export, some of our science, some of our smarts around food technology that have proven, validated health claims that add value to these types of products. Another kind of key thing for New Zealand in particular, and perhaps in Australia with indigenous plants, is that there's a lot of work going on looking at ways of potentially leveraging and adding value to products utilizing indigenous plants and extracts from those in food and beverage products, as well as nutraceuticals, of course. I think something else to mention as well, what we're really seeing, which is really driving the exciting space in food and beverage innovation, is that there's huge amounts of stuff going on in these kind of core areas, and I've probably missed some, but med tech, there's some amazing stuff happening. In terms of the way and how we're going to be treating and preventing ailments through food and personalized nutrition, wearable devices, and so forth to monitor your health and improve your health is going to be something that we're going to see a lot more of, and people taking greater control of their health through that way. Health and nutrition, that alone in itself, I mean, there's huge amounts of research going on in the gut microbiome space. We're learning so much about how that's directly associated with so many different types of conditions, as well as your overall health and wellness. Obviously, inflammation is a big part of that, and that's linked to many diseases as well. And some of that, at least, it looks like it can be controlled through your diet. I also think, like, just you probably heard some of these, the health is the new wealth, those types of things. I think just in people's minds, people are taking greater control and recognizing the importance of what you eat as being very critical to your overall well-being, not only your physical, but your mental well-being as well. I've heard things of, I'm big into my running, and I often hear things about 80% of what you do comes down to your diet rather than your exercise. And it's more about the fact that you can't, well, as far as I've experienced so far, you can't out exercise, or you can't exercise out a bad diet. So there you go. So I think people are starting to recognize the importance of your health through your food. Sustainability, obviously a huge area. There's a lot of technology going on in efficient crop and farming practices. Something that's probably a bit controversial, but GMOs, I personally think there's a big opportunity for that to drive innovative processes. There's obviously a lot been going on in the plant-based alternative space, but personally, I think what's going to be the biggest disruptor when it comes to sustainability is going to be shifting over time, potentially faster than slower, is the tradition from traditional pasture-fed animals to fermentation-based technology. So essentially our proteins and other nutrients are produced in factories through fermentation technology rather than everything being grown out on the land. And I think that's hugely important, as I'll get to a bit later, for New Zealand, because we have a limited geographical land space. Then we need to kind of keep our clean green image, and not only our image, but we've also got to keep our country clean. And finally, I won't talk about it a lot, but obviously robotics, I think, will have a big impact in the food and beverage space as well. Huge efficiency and efficiency improvements in factories, but also things like what we're going to see over time is potentially in-home technology through robotics for cooking and so forth. So with all that, those potentially are going to combine together, and we're going to start to see a big shift in the food and beverage sector, I think. So when we look at New Zealand specifically, and perhaps some of these might ring true for some of the other markets, perhaps in Denmark, Belgium, Netherlands, other areas like that, or Singapore. In New Zealand, at least, like I mentioned before, the commodities, these products like honey, milk, meats, all these fruits, I should say, that are exported from New Zealand, a lot of them are kind of high volume commodity products. And I think those are the areas that are potentially going to be primed for disruption over the coming years and decade as we move forward into alternatives. Secondly, I think a key problem for New Zealand is we're very far away from a lot of our export markets like China. And therefore, we're at a significant disadvantage to other competing countries that are able to make products for potentially a lot cheaper in terms of shipping and so forth, and shelf stability. Finally, just in terms of what are the other issues in New Zealand, small landmass. It's a small country, and we export a lot of food. And so with that, we obviously have to try and find ways of doing that more efficiently. And I think I'll probably get a bit ahead of myself, but when it comes to intellectual property rights, there's opportunities to export our smarts, export those intellectual property rights rather than the physical goods themselves. And that will help to alleviate the pressures on the land. And I think fourth is less about a physical thing. It's more of a psychological or approach to things. But New Zealanders often take that she'll be right attitude to intellectual property. And sometimes, more than often, I hear stories of, giving away those amazing, developments that you've come up with over years of research and money being put into it. And it's a lot easier for other countries that have much greater ability to kind of scale things up, and they're closer to the market. So it's a lot easier to kind of steal those and do better. So that kind of is a good segue onto my next slide, which just shows a number of OECD countries over the last kind of 10 or 11 years, looking at the number of patent filings. And so you can see down second to the bottom is New Zealand. And they are, New Zealand as a whole is, second to the bottom in terms of the total number of patent filings. So that is unfortunate. I think that is a good indicator of the innovation output and how we can protect the IP. Sorry to anybody that's on the call from Singapore. And unfortunately, at least in terms of the search that I ran, it's even lower. But I think something to bear in mind, Denmark is a similar population size to New Zealand and produces a lot more in terms of IP outputs and in terms of patent filings. Something to bear in mind, though, obviously, is the R&D expenditure. So looking at statistics from 2020, New Zealand only had $2.8 billion of expenditure into R&D in the food and beverage sector. And so when you look at it from that perspective, New Zealand's actually quite efficient in terms of converting that money into patented technology. I think we came out second after Netherlands in terms of that conversion from R&D expenditure into patents. So we're good in terms of converting, but we still need to do more in terms of protecting our smarts. I didn't want to scare you with China, but if I put China in on this graph, you wouldn't be able to see any of these other countries. So it would completely blitz the statistics we're seeing here. So I should also just point out that the fact that we in New Zealand are able to do such a great job into converting the R&D expenditure, even though it is low, into patented technology, and that's a good indicator of innovation. It does kind of point out that if we do get more funding through, for example, through government intent, that I think that we will be able to really boost up our innovation outputs significantly as a result of that. So I'm a pro for that. And just to kind of build on this is just some examples I picked out. You probably might see a bit of a trend. A lot of the stuff here is in relation to health, and it's a particular area that I'm very focused on in the food for health space. So these are patented technologies that have now been commercialized. You might see, the Fonterra's patent towards MFGM for cognitive performance in infants. You've got Comvita's patent in relation to its honey and its UMF factor. Arepa, one of my clients, which I'll talk about shortly, its patent towards mental clarity drinks. You might have heard, I'm guessing there's some people on the line from Massey. So their patent, which was towards the iron casein complex for iron fortification of milk, is now being acquired from Nestle and is now being commercialized. And the list goes on. So there's a few here that, some really great stories. And I think that, as we build up this experience and knowledge, it's going to help other companies that are startups, learn from those experiences and build on what we've achieved so far. I'll move on to the next slide. So now getting on to kind of what is intellectual property, that you will see different definitions, but they all kind of are variants of what I've got here. So essentially, it's an innovation-derived asset, typically knowledge-based, that if protected and applied correctly, and that's a key point, can give you a sustained advantage over your competitors. So it's not just enough to protect it. You actually have to use your intellectual property effectively to get that sustained advantage. I've listed a few points here about why intellectual property is so important for food and beverage companies. And as you'll see, there's a common trend here, except for the last one. The key point being that generally in the food and beverage sector, at least what I've seen, is that companies will use intellectual property rights like patents or trademarks in order to proactively kind of lead to positive things. It's not a negative, it's not a kind of litigious type activity. Most of the time it's around developing new opportunities and building. So for example, looking at securing and funding an investment, that's really important for startups. I don't know how many times I've heard from angel investors asking startups, and indeed the one I was involved in, what kind of IP rights do you have and how are you going to use those to stop your competitors, considering you're just a small player? Attracting collaboration opportunities. I think it's really important if you are going to collaboration with universities or other groups that you establish what is your background intellectual property before you go in there, so you kind of identify what it is you're bringing to the table. And it also helps to attract that because they can actually see what you are bringing and what would work well with what they've got as well. Licensing deals, obviously, by having some kind of intangible right, like a patent, you can actually structure a licensing opportunity around that. And it can be, for example, limited or restricted to particular markets as well. Protecting a competitive advantage in market, obviously that's kind of what I was talking about before. When New Zealand is exporting goods overseas, we have this added problem in terms of distance to market. And so if we are charging a premium, we can protect that premium because no one else is able to make that product for cheaper. Another key point about the food and beverage sector, compared to the pharmaceutical industry, it's generally a lot faster to get a product to market. It might be in the vicinity of 1 to 3 years, depending on what it is, versus in the pharma industry, it could be up to 10 or 15 years. So you can utilize IP rights like patents a lot more effectively, I believe, in the food and beverage sector. Sometimes, with pharma, they've developed patent term extensions to allow for that. But it's, I guess, one of the key advantages of being in the food and beverage sector is generally from idea to market, it's a shorter duration than the pharma industry. In terms of marketing your smarts, I've seen this a lot with food and beverage companies. Just using your IP rights effectively to kind of show that you're an innovative company. So it's not, you don't need to just stick your, again, turning to a patent as an example. You can, yes, it can be in your register of IP rights and keep it internally for use, but also you see a lot of companies that are using that to kind of advertise how innovative they are. And I'll get onto an example of that shortly. Internal reward and recognition. A lot of universities are doing this really well, but allowing kind of the inventors and new innovation to be rewarded as part of their contribution. And I think it's just me personally, I've been listed as an inventor for a number of patent applications, and it does feel quite nice to get that kind of recognition. And I think it does help in terms of staff retention as well. Another big one as well, targeting multinationals for your exit strategy. This is something that I see time and time again, and it's become almost a standard path where you have a startup, you kind of profile the multinationals that you're looking at targeting, and you develop your R&D strategy and your technology for that end goal. And it's something that with some really clever searching, you can actually come up with key areas, hot areas that that these multinationals are interested in, and target your innovation strategy along those lines, as well as obviously protecting your IP rights in that space too. And then finally, what I mentioned, litigation, yes, it's important, but it's quite rare in the food and beverage industry. And most of the time I see that those IP rights are being used in a positive way. So as I mentioned, client story, this is a client, Aripa in New Zealand, that I've been working with for a long time. Angus Brown, the co-founder, when he first started out 7 or 8 years ago, he was, I believe, a one-man band or one other person. And over the 7 years has now grown. And just in the last year or two, I think their team is up to about 20 or 30 people now. So huge growth and doing amazing work, exporting and broadening their horizons overseas. If you don't know, this product is all about, as I mentioned in the previous slide, is all about kind of this brain drink, nootropic brain drink that provides mental clarity. And I've got a bit of a testimonial from him that I'll just read out to you because I think it kind of brings it nicely together. We have a unique set of ingredients in our Aripa product range linked to mental clarity and cognitive performance. This is a rapidly growing area of health, and we're seeing huge consumer interest, and for that reason, also new competitors entering the market. For us, having a formula in Aripa that's protected by IP means a lot to the business, as it helps to protect and leverage our points of difference against new market entries. So we've purposely built IP into the company's culture. As a result, we have an IP strategy that involves many elements, including registered trademarks to reflect our unique branding, patents for the product and its uses, and plenty of confidential information that we closely guard through trade secrets and know-how. Our products even say patented formula on the pack to reinforce this innovative messaging, and that's what I highlighted before. This is particularly important now with our offshore expansion and growth. We also utilize consumer relevant health claims, and I'll talk about that shortly, linked to our brand and our story that we achieve through our IP and our healthy nature of our products. Now through collaborative research with High Value Nutrition, we're further investigating the health benefits of the ingredients in Aripa to strengthen our IP position and discover new benefits. This is powerful as it protects our formula and its uses from competitors looking to copy us. So I think that's kind of a nice summary of how New Zealand food and beverage company that's relatively small and growing rapidly can use intellectual property, and like Angus said, is built into the kind of the culture of the company. So next slide is just about, kickstarting your IP strategy. If you're totally new to this, what are some easy ways I can kind of get things rolling? So I've tried to keep it as simple as possible, and I'll talk to each of these. Good decisions to make early. Who is your IP hero? So consider in your business or your startup, who is going to ultimately drive and review and update the IP strategy, and also kind of be the hero in terms of building that company IP and innovative culture into new employees as it grows. Obviously, if the skills don't exist in-house, there's the opportunity to outsource that. But my recommendation is to really have somebody internal that it really drives that. I think it's important to recognize that what I've said is you've really got to be careful, and this is important for larger, multinationals or bigger companies. You've got to be really careful not to just have one person siloed in the corner managing the IP. It really has to be innovation and IP rights really need to be part of the wider discussion, and obviously the key decision makers need to be well aware of intellectual property rights and how they're being used for the overall business strategy. The next point is choosing your A team. You're probably going, what's he talking about? I think the key thing here is just consider what your distribution is going to be like. So obviously with a startup or even any company in the space, you're going to be utilizing people outside of your organization who are going to be somehow involved or be accessing your intellectual property in some way. It might be, collaborators, like I mentioned before, it might be distributors, it might be franchisees, those types of things. So you need to make sure that you've covered off confidentiality provisions, distribution agreements, licensing agreements to cover all of those touch points, all those people that you're going to be engaging with as you go through the process. Go to launch. So your IP strategy needs to consider the risk of your commercialization project or your timeline. That is a big thing I've seen. If you're a larger company and you've got 50 projects on the go, it doesn't make sense to be necessarily trying to protect the IP rights of everything. You need to kind of carefully consider what is the risk associated with this project. Is it likely going to be commercialized, or is there an 80% chance this is not going to get to market? So it's really important you kind of understand that. You need to understand, like I said, the timing of the launch, expected iterations of the new product and where it's likely to go in the future. Are you going to develop new SKUs, for example? Expected market size and geographical target markets. And of course, what is your budget? What I mean by that is not only your R&D budget, but also what is your budget for potential protection of those IP rights. Just a bit of a story. I've often seen large corporates where the two areas, the group that's managing intellectual property and the group that's commercializing, it might be the marketing team, R&D team. Sometimes they don't kind of marry up, and they're not talking to each other. And I think it's really important that you really kind of factor in all of those into the equation when you're making decisions about when you go to launch, when's the right time to be looking at IP protection and so forth. And then finally, know thy enemy. I think here the important thing is just to make sure that you identify who your competitors are, and that could be through the likes of a SWOT analysis or due diligence, however your company does it. But you really need to understand who are your competitors, what are the key risks there, and included with that is what does their IP portfolio look like? Are there any potential IP roadblocks in terms of brands or trademarks, registered trademarks? Patents, obviously, those types of things. If you're considering markets like the US, you might have heard, but it's very litigious, and we've heard lots of stories about companies doing everything going hunky-dory in New Zealand, Australia, and then you head over to the US and you get slapped with a cease and desist letter. And so you just have to be super careful about understanding which markets you're going to be going into, and also making sure you don't end up in a sticky situation. There's also stories you might have heard in China. This is more of a branding thing and trademark, but these, I think they're called IP pirates, but essentially if you go to like an exhibition or with your new product and you're expecting to commercialize in China, sometimes the Chinese IP pirates, the little groups that get together, and they will end up taking your brand and filing a trademark application in China, and then holding you to ransom and demanding big bucks in order for you to get your trademark back. So things like that, just understanding what are those potential risks and trying to mitigate those as best as you can. So next kind of slide just talks about where are you in your IP strategy journey. And as you go from left to right on the screen, this kind of you might see where are you potentially in this space. Generally speaking, a minimalist is probably going to more describe an early stage startup, and as you grow and expand and get funding, and then build into a larger group that expands offshore, is where you're going to be in that kind of more proactive stage. So as a minimalist, it's not the same as being I'm a minimalist at home, much to my wife's dismay, but what I'm talking about here is intellectual property. In terms of what we're looking at here, so obviously identifying and marking anything that's potentially got copyright. I'll talk about copyright soon. Trademark clearance, so making sure that your actual brand can be used. Identifying and securing your trade secrets, and doing as best as you can. And when you're in a small group, might just be yourself or a few others, just at least documenting those to know that everybody's aware that that is critical trade secrets. Obviously, just doing some background work around competitors and avoiding IP disputes. And that can be a really important thing when you're planning out your your R&D and overall commercial strategy, is where are areas that are likely to be less litigious, or is less likely to be major roadblocks ahead. Often I see companies that will do 5 years of R&D and then decide that they're going to do some searching. And I think it's better generally when you're in that initial stages to really do some searching up front to get a feel of the overall landscape and know where the different players are and where are areas that you potentially might want to avoid in your strategy development. I'm not going to go through all of these, but as you can see in protective, that's when you start getting into ensuring you've got good agreements around IP that you own or that is being licensed to your company. Start using, where applicable, registrable IP rights like trademarks, designs, and patents, and plant variety rights. They're called plant breeder rights in Australia. And then actively manage that IP schedule to make sure everybody in the company as you're growing is aware of that and you've got good stakeholder engagement. And then when you get over to the right-hand side, I won't go through all this, but it's more about being proactive, potentially doing monthly searches on competitors, seeing where they're at, conducting freedom to operate, and enforcing your IP, and potentially opposing any kind of key competitors. An example of that you might have seen recently is the patent opposition between Fonterra and Perfect Day. And I won't go into any detail, but that's the kind of when you get up to that stage where you can potentially start opposing other companies' patent rights or other IP rights. So now this is getting down to the nuts and bolts of what we're going to be talking about today. So IP rights relevant to IP relevant to the food and beverage industry. I'm sure most of you will have heard about the ones on the left-hand side, and I'll just go into those in a bit more detail in the coming slides, but I just wanted to talk briefly about the kind of less conventional IP rights that I see that are being used that are either non-registrable or less conventional. Self-substantiated health claims. This is now a new process. So it's been for a few years in New Zealand and Australia. It's governed through FSANZ, which allows you to make kind of unique health claims around like a food health relationship. So it might be in relation to a prebiotic that you've developed in relation to gut health, for example. And many countries around the world, many jurisdictions have similar frameworks in place. You might have heard of the EFSA in Europe. In New Zealand and Australia, governed through FSANZ, there's now about 500 there's about 500 notified self-substantiated health claims. So that once that's notified, it allows those companies to use that health claim on their packaging. And it is often very closely linked to the health, obviously the health benefit they're trying to portray as a competitive advantage, and is also often very closely linked into their brand as well and the messaging around that. Just in terms of self-substantiated health claims, it is quite a lengthy process. If you're going to do it right and not get challenged by the regulatory bodies, you have to build a dossier of information, typically through human clinical studies that have been published. And it needs to provide a significant level of scientific evidence to prove that the food health relationship is effective and is going to be present in the food that you're actually delivering it in. The cool thing about self-substantiated health claims is that dossier is actually kept confidential. And so it's not easy for another company to come along and make the same health claim as you. They would have to go through the exact same process in terms of developing that dossier of information, which can take a lot of time. And potentially, if there's limited amount of information, you might even need to do your own human clinical trial, which, as we all know, can be very expensive, unless you've got funding by High Value Nutrition, of course. Just a little plug there. So what am I going to talk about next? There's also pre-approved health claims in New Zealand and Australia. I can't remember off the top of my head how many there are, but there's a lot in terms of different nutrients and vitamins, minerals that can lead to pre-approved health claims. All you need to do is make sure you've got, I think it's 25% of the RDI in that product serving size, and that you have to meet a threshold in terms of overall health of that product as well. That's called it's a nutrient profile scoring calculator. So that is also an interesting form of intellectual property, just because it can be closely linked to trade secrets. So you keep your dossier as a trade secret, and if it's a pre-approved health claim, there could be trade secrets around your formulation that allows you to achieve these health benefits and health claims, but in doing so, actually able to make a product that tastes good and is shelf stable and doesn't cost the earth. So in terms of money and environmental. So I think those are really important for people to recognize as IP in the food and beverage sector, and to utilize that effectively. I've seen a lot of companies that actually go through the self-substantiation process and at the same time actually file a patent application in relation to that health, food health relationship as well. And that is because, like I said, potentially other companies could go through that same process, even though it is difficult, in order to get that health claim. And also a lot of strategies that some companies, in particular ingredient companies, are taking, where they will use that self-substantiated health claim as a form of licensable document, where they can then sell that dossier. Well, not, when they sell the ingredient, it comes with a kind of a license to use the dossier to make the health claim. So you're passing over that confidential information, and it can be more tightly controlled through the use of a patent, for example. I talked a lot on that first one, so I will probably try and skim over some of these others a lot quicker. But plant variety rights, the likes of, for example, Zespri in New Zealand, they use plant variety rights very effectively in order to control their IP and use that as a mechanism to license those rights, so growers can use those. Copyright, hugely important, obviously, in the food and beverage sector, where a lot of things come down to the look and appearance and artistic works. Just think, for example, about I'm a craft beer fanatic. I don't know, maybe a number of others are, but it's amazing to see the incredible design work that goes into the outside of the beer can. My favorite is batch brewing. I don't know. And the interesting thing is I will often go to that beer just because of the cool look of the actual can itself and the design on the outside of it, opposed to actually what it actually tastes like. So that shows how much of a beer connoisseur I actually am. But I think the good thing about copyright is it is free and it's automatic. As soon as you've developed that artistic creation, it does last for a long time, but it can be difficult to enforce. So part of the enforcement is that you actually have to prove that somebody's copied your artistic creation. Agreements, hugely important in the food and beverage sector. It's often the mainstay of your operation, and it kind of is a backbone of what you're doing on a day-to-day basis. So it's really important that you treat those as IP, as your intellectual property, and that you have, it's not written on the back of an envelope, or it's not a handshake, that you actually go through the formal process of getting those agreements drafted by a commercial lawyer, and that there's suitable intellectual property clauses in there in relation to ownership of the IP, and obviously confidentiality clauses and the like. The next one, partnerships and relationships, is probably a kind of a softer version of that, but is equally important in the food and beverage sector. Everything comes down to relationships in the food and beverage sector. It's an emotional industry, and those partnerships and relationships are hugely important. So again, I personally recommend that when you're developing your IP schedule, that you recognize as part of that, who are your key partners, the key relationships that you have, who are the people that are going to open potential doors for you, and keep those really close to your chest. Confidential information, trade secrets and the like, these are really important in the food and beverage sector. It often comes down to questions I get: do I patent or keep this as a trade secret? Every situation is obviously different, but a really well-kept trade secret can be very powerful. Obviously, there are pitfalls and things to watch out for. Probably the biggest one, especially as your company grows, that companies could end up leaving and going to their competitors. I'll skip over the last one just because I'm conscious of time, but I'll keep going. So in terms of a patent gives the owner the right to prevent others from making, selling, using, importing, or otherwise exploiting the invention in the patent within that specific country for which it's granted, and it typically is for 20 years, although, as I mentioned, sometimes you can get extensions on those. Pros, common tool used in the food and beverage industry. Some people kind of say, oh, you can't patent stuff in the food and beverage space, but I promise you that is not the case at all. Nestle, for example, has 48,000 patents on the last count. So much shorter lead time to market than pharmaceuticals. They can be bought, sold, and licensed. It can be used typically in a positive way instead of a negative way. And as I mentioned, a good show of an innovation. There are some cons, of course, like anything. High threshold for grants, so you obviously have to prove during the process of getting a patent that it's novel and inventive. You must disclose your idea fully in the patent, so that's the trade-off for getting the 20 years monopoly. You need to file in each country specifically. It can be expensive, it can be slow, although that can be a good thing. And as I mentioned, it only lasts 20 years. And if you do go down the track of litigation, it can be quite expensive. Here are a few things that you're probably going, well, can I potentially patent this? Yes, to compositions and so forth, new uses, therapeutic or preventative methods of use. Obviously, that's country specific. Some countries don't allow them. Methods of manufacture, new tools and machinery, and innovative packaging all can be patented. And I'll obviously go into a lot more detail around patents in the next webinar. Trademarks, I'm going to go through this very quickly because I want to get on to the mock case study, but you will see all this information when we send through the deck. So as an example, Zespri has this registered trademark. It's in relation to your badge of origin, your brand, and that can be either registered or unregistered. There are a number of pros to registering your trademark. For example, you can continue to use that indefinitely. It doesn't have a 20-year period like a patent, but as long as you continue to use that and pay for your renewal fees, you can essentially have that trademark protection forever. It gives something different to being unregistered, is you can actually get that nationwide protection essentially immediately. You don't have to wait until you've established reputation. And another good advantage is that actually provides a defense to infringement of another trademark if you've got a registered trademark yourself. Again, I'm not going to read through this because you can see these for yourself. And I'll skip over this slide. You will see this when we send through the final pack, but it just shows the types of things that you can actually get trademark protection for. Some of those things on the left down the bottom are very, you don't see them very often, quite rare. As an example, in terms of a moving image, think of the M&M's character animations or sound, for example. An example in the food and beverage space is the microwave ping sound that you get with the McCain, you've done it again. So there's a few examples here and there of, quite obscure trademarks getting registered in the space. Registered designs, this is where you try and protect the features of appearance of a product. Generally, they're focused on the design elements and eye appeal of the product rather than the functionality, but it can include functionality as well. The example here is the Burger Fuel Doofer. I don't know if you've seen that. I actually use it as an example when I'm talking to my kids about what I do, because they think I just write stuff on paper. But I take them to Burger Fuel and I go, this is the doofer. This is a whole bunch of different elements of intellectual property, brand, design, potential patent. And I kind of explain through that as a good example of what somebody in the intellectual property space actually does. There's a number of pros and cons. It's only 15 years protection in New Zealand. And it's quite limited in terms of how you can kind of capture the protection. Is limited to the overall appearance, so potentially quite easy to get around the intellectual property rights if you make it look different, but it still has the same concept. And again, can be for the shape and configuration, pattern or ornamentation, generally speaking, of a product. And here is the overall path to getting a registered design, which I'm happy to kind of go through with anybody in more detail if they want. So in terms of the mock study, this hopefully will kind of bring together some of the things I've spoken about today. I will read it out and just kind of keep in the back of your head the two questions that I'm going to be asking, and you feel free to put them into the chat afterwards. What elements of an IP strategy has Stephen, the guy that'll introduce, employed? And then would you do anything differently? Okay, so Stephen's New Zealand-based startup MLK Limited is now very close to launching its first product, a plant-based milk based on pine nuts, avocado, and hemp, which he's coined Gutsy. It's a unique combination of prebiotics, and this has led to an unexpected positive impact on gut comfort and in preventing inflammation when drunk on a daily basis. The company intends to launch Gutsy into New Zealand as a test market before expanding into China, a market he's only had minimal experience in. Stephen also recognizes the USA and potentially elsewhere as big opportunities, but the company doesn't have the presence or ability to grow outside New Zealand anytime soon. Plus, he's quite keen on selling his business in 5 years and thinks this new product will be his grand finale. Stephen started the project by collaborating with a leading university to develop the method and product. Stephen smartly set up a clear agreement and clauses to transfer all the IP to MLK Limited and put important confidentiality measures in place too to prevent accidental leaks. After 6 months of research, things were starting to look very exciting on the gut microbiome front. Stephen got his patent attorney to do a search, which showed that the prototype's ratio of prebiotics, its health outcome in vitro trials, and the prototype manufacturing process all appeared to be very unique. In addition, no significant patent infringement risks were identified. He subsequently filed a provisional patent application to protect composition, its use, and method of manufacture as its key IP position. 8 months later, the High Value Nutrition funded clinical trial data showed clinical significance, so the data was added into the patent specification for a PCT application. And I'll go through what a PCT application is in the next webinar. The data was also used to boost up a scientific dossier of evidence to secure a FISAN self-substantiated health claim for gut comfort and preventing inflammation. Through his attorney, Stephen conducted a clearance search for Gutsy, the name Gutsy, who then filed a trademark application in New Zealand, China, and the US. Knowing his limits, Stephen also lined up a licensing agreement with a large US-based company with 10% royalties via exclusive rights to the Gutsy patents, Gutsy patent and trademarks outside New Zealand and China, as well as confidential rights to the know-how for the confidential rights to the scientific dossier of evidence for the health claim, and confidential assistance for the know-how around the raw materials, suppliers, and its manufacturing process. Even better, to minimize Stephen's outgoings, he negotiated the US company to cover all the patent costs in the US as part of the license agreement. Assuming 3 years of pre-agreed sales targets, the US company will buy out the entire business for a pre-agreed value of 10 million, including the newly developed IP towards Gutsy. So taking that into account, feel free to kind of throw down any ideas or key points that you heard through that about what elements of an IP strategy did Stephen employ, and potentially would you do anything differently? I'll just give you 30 seconds to do that, or even less, 15 seconds considering the time. And then I will kind of cover off what I have come up with. I'll move ahead anyway. So you might have heard, obviously, Stephen went ahead and did some searching. He obviously filed a patent application. He's looking into health claims through that self-substantiation route. He's registered his trademark. He's looked at licensing agreements and royalties, and he's already lined up potential acquisition as an exit strategy. So there's a number of elements of an IP strategy that Stephen's employed here. But I think purposely I left out a few. I'm not sure if you picked up on them, But for example, he probably jumped ahead a little bit. He didn't do his due diligence and understood the market. So has he potentially invested a lot of money in progress clinical trials without first testing the market in New Zealand and China, or even the US? You know, what is the consumer appetite? What's the key marketing message? What's the health claim? What resonates with consumers? And what is the actual size of the prize? And I think you need to really understand that before you finalize your IP strategy and level of investment. Probably before he went ahead and, you know, did the second stage of the patenting journey in terms of filing a patent at PCT level, he hasn't utilized that time to really test and make sure the product is actually commercializable. So does it achieve the correct profit level? Can you scale it up? What's the shelf life like? What's the sensory and all that stuff? So he hasn't kind of done his due diligence in that sense. He probably missed an opportunity to seek funding. As I mentioned, he could have done some capital raise and brought some other people into the game early on in the piece, perhaps soon after filing the provisional. And something that's important in the food and beverage sector, by doing capital raise and getting angel investors, is you also bring to the table a lot of experience in that space as well, not just about money, it's about experience. And then finally, I think he was probably a little bit premature in agreeing to sell all of his intellectual property with the US company. I think potentially he could have gotten a lot more, or potentially over the year when he's developing his product could have realized that there's bigger opportunities out there. So I will leave it at that, just recognizing that it's 3 minutes to. I just want to leave a couple minutes for any questions. Just wanted to highlight, this is what Spruson and Ferguson's all about. And we're biggest in Australia and Singapore in terms of patent filings. We've won heaps of awards, and we know what we're doing. So we've been around a long time. Come and talk to us. I will leave this last thing, but I just wanted to bring to your attention, we'll send out a link to you, but there's a huge amount of information on our website. You can go to this IP hub, technology transfer hub, where you can get a lot of information. You register for it and you'll get free access to this. So we'll make sure that we send through that link. Anyway, over to you, Mike. Thanks, and apologies for going over time there.
Okay, thank you very much, Peter. That was a very interesting and an excellent webinar. I see we have a few questions that have come through, but I think given the time constraints, I probably just will give you one of those questions. So apologies to those who have asked some questions we just won't get to today, but Peter will come back to you directly. So let me, in the few minutes we've got left, Peter, let me just ask you one question. So given all the rights you've mentioned, what form of IP right do you think is the most important to a food and beverage company? And I think that might be a bit of a tough question to ask, but what have you got for that?
Yeah, well, I think the key thing to recognize is that it depends on the situation. Every company is going to be in a different stage, and depending on what you're working on, one type of intellectual property could be way more important to your business than another type. Just to give you a few examples, you know, if you're the likes of KFC, for example, and you're very established, they will be looking at obviously their brand. The brand, when you're a very established company, can be probably the most valuable form of intellectual property right. But obviously, you think about their 11 herbs and spices that they keep under wraps. That is an example of something, a form of intellectual property that they keep very well close to their chest as a trade secret. Yeah, but if you're an early stage startup and you've got some kind of really exciting, you know, technology that you've developed and you're looking for funding, the most important form of intellectual property might be ensuring that you've got that secured via, you know, at least a provisional patent to make sure you've covered your bases there. But I think, like I said, it really depends on the situation, and it's not a one size fits all, unfortunately.
Yeah. And speak to your attorney early to get advice, I think, there, because of the complexity that's involved. All right, that concludes our presentation today. And again, I'd like to thank everyone for attending. If you have any further questions or want any further information, please reach out to Peter directly. His email, his contact details are on one of the slides. So thank you, Peter, and thank you for attending today.